Good evening. Thank you all for being here. My article is entitled Parotta v. County of San Diego, an individual right to self-defense outside the home, and the application of strict scrutiny to Second Amendment challenges. Now, in 2008, the Supreme Court famously in the Heller decision declared the Second Amendment to be an individual right for all citizens. In 2010, they later applied this to the states in McDonald v. Chicago. Since that time, courts across this country have grappled with what exactly they're supposed to address Second Amendment challenges to. Should they use a heightened level of scrutiny, of strict scrutiny, intermediate scrutiny, or in some cases, is rational basis appropriate? Then came Parotta. Now, Parotta started when a gentleman by the name of Parotta applied for a concealed weapons permit in San Diego County. Now, in California, there are originally two ways to carry a firearm outside in the public. You had open carry, which would be the open carry of a firearm on your hip, and concealed carry. In order to conceal carry, an applicant is required to demonstrate good cause as well as meet background and training requirements. Now, the law in California for a concealed weapons permit allows each individual sheriff for the counties to decide exactly what good cause is. 40 counties in California allow that good cause is simply an applicant stating, "I wish to carry a firearm for self-defense." San Diego did not. In order for an applicant to attain a CCW license in San Diego, they had to set themselves apart from the mainstream to show that they had a heightened need greater than their fellow citizens. Parotta challenged this law as unconstitutional in its application. Now, there's a little quirk to Parotta. While it was working its way through the courts, California actually banned open carry. So the only method that a person could now exercise their Second Amendment outside the home in California is concealed carry. 4 of the other circuit courts besides the Ninth Circuit have found that the Second Amendment extends in some manner outside of the home. From there, some courts have applied strict scrutiny to analysis about limitations. Other courts have applied intermediate scrutiny. And then came the Ninth Circuit. A 3-panel court decision marched through the history and traditions of our country, finding that the right to carry a firearm in public in some manner is guaranteed under the Second Amendment. A state can either allow open carry or concealed carry, but they have to allow one or the other. They can't ban both. The 3-panel of the Ninth Circuit found this to be true and invalidated San Diego's law because it effectively took the right to carry a weapon in public off the table within those counties. Now, Parotta got even more interesting after that. The sheriff, who was actually part of the lawsuit, chose not to seek a rehearing en banc after the case was decided. California, citing that a state law had been now implicated, decided to intervene in the case, and an en banc hearing was done. The en banc court invalidated the 3-panel decision, upholding the constitutionality of San Diego's application. But as Judge Callahan, and I'm so excited Judge Baio's here because he also dissented, Judge Callahan's main dissent noted that the majority opinion set up what they called an elaborate straw argument to knock it down. By this, what Judge Callahan meant was California, the en banc panel, didn't answer the right question. The en banc panel narrowed the issue specifically to, is the right to carry a concealed weapon outside of the home a fundamental right? Finding it wasn't, they applied intermediate scrutiny to the application and upheld the law. But the problem is that with the en banc opinion is they don't address the actual issue with California's regulatory scheme. Because by invalidating or by upholding San Diego, and at the same time open carry now denied, citizens of San Diego County now have no ability to carry a firearm in public, which the 3-panel has shown to be a constitutionally protected right. Now, as courts continue to battle with what level of scrutiny they should apply to this, what my article details is that based upon language from the Supreme Court, decisions about denial of certiorari in some cases, and other state Supreme Court cases, the application to firearm outside of the home should be done under a strict scrutiny analysis. And even under a strict scrutiny analysis, the laws that we all would love to have upheld, such as felons' prevention of a firearm or allowing firearms out of the hands of mentally ill, can still be upheld even under a strict scrutiny test. So it is my hope that the Supreme Court, which Parotta just applied for certiorari, will take up this case, finally step into this law, and settle the issue among the circuits about what exactly courts are supposed to do and what level of scrutiny they should apply to Second Amendment challenges outside of the home. And my hope is that the Supreme Court will invalidate the en banc opinion, reinstate the three-panel, and give back to Californians the right that they know have under the Second Amendment to protect yourself outside of the home. Thank you.
Amen.